Now that cannabis is legal in Canada, one of the challenges for police has been finding a roadside testing device for cannabis impairment levels that is accurate. Kyla is a criminal defense lawyer practicing at Acumen Law Corporation of Vancouver and joins me now via Skype. Welcome to Bridge City News, Kyla.
Thank you for having me.
Now, it's bad news if the roadside impairment testing device turns out inaccurate results. What kind of devices are police departments starting to use right now?
So right now there are one device that's approved in Canada and one that is in the final stages of public consultation before approval. So the first one is the Draeger Drug Test 5000. That's a roadside saliva testing device. And the second one is called the Abbott Sotoxa. It's renamed from the Allaire DDS2, which was field tested prior to the roadside saliva testing legislation taking place in Canada.
Now, I understand that you actually own one of these and you've been trained to use it, but you tested this piece of equipment and it actually gave a false positive to people who ate poppy seed loaf?
Yes, we own the Draeger Drug Test 5000, and we did a number of tests a couple weeks ago involving different substances that might produce false positives. We had a positive test for opiates on the basis of somebody eating poppy seed loaf. Even half an hour after they ate the cake, they were still producing a positive reading for opiates. Now, that's not as much of a concern in Canada because the Draeger Drug Test 5000 here is being programmed not to detect for opiates. So most people are not going to find themselves in a difficult situation as a result of that. But we also got false positive results on the device for THC for an individual who had only been using CBD, and a false positive for cocaine for somebody who had consumed coca leaf tea.
As you mentioned earlier with the Draeger, is that it's unable to differentiate between THC and CBD. Could this potentially land an innocent driver in jail?
This could have huge consequences for innocent people. CBD is non-impairing. It doesn't have any psychoactive properties or effects on people. And a lot of people take it for pain management, to deal with anxiety, to deal with medical issues. It's been used in medical applications in Canada for a long time. And so people who have legitimate medical conditions that may cause them to present as though they're impaired because they have a back injury and they're walking funny, or they have a toothache and they're slurring their speech, something like that, that could then be used in conjunction with the saliva test result to give the officer basis to arrest them, take them to jail, subject them to further testing, and potentially found a criminal charge.
Now, Kyla, what about the criticism of the Draeger for apparently not working well in colder temperatures? As you know, you and I live in Canada and can get a little chilly here at times.
It is a big concern, because we have a climate in this country that is varied, and because large portions of the country, I'm lucky to live in Vancouver, but most of the country for half the year is outside the operating temperature of the Draeger Drug Test 5000, which is 4 to 40 degrees Celsius. So we're going to see cases where there are false positives. They did a study in Sweden involving the use of the device in colder temperatures, and they found 15% false positive rates when it was used in those conditions, which, from the perspective of a defense lawyer and of a driver, it's something that I don't want to take a 15% risk going down the road that I'm potentially going to be arrested on the basis of the weather.
Now, Draeger representatives have responded to these criticisms and say the device you have tested is not the same device used by Canadian law enforcement agencies. Is it different from the one that you have?
The only difference in the device that we have and the one that's used by Canadian law enforcement is in the programming for what types of substances are being detected. That doesn't change the analytical method that underlies what's being done with the device. In fact, it's the same analysis. So what we're testing is the science. We're not testing the programming. And the science isn't going to change in Canada. The science stays the same.
Now, Draeger officials also say that the device used by Canadian law enforcement agencies can only detect cocaine and THC, and that it's not able to detect opioids. So eating poppy seed loaf would not actually result in an arrest. Your thoughts?
It wouldn't result in an arrest, but there's an interesting provision in our criminal code that allows a police officer at the end of a drug recognition evaluation, which is a 12-stage process to determine impairment, to take a bodily sample from a driver to test for one of 7 categories or classes of drugs. And if the Draeger Drug Test 5000 is used in that context, and the government uses it and gets it programmed to test for opiates, then we could see false positives from people in those situations. Those results would be admissible in court as proof of impairment at trial.
Are police officers able to simply use a field sobriety test on drivers? So would this have a proper level of accuracy in determining whether an individual is impaired by cannabis?
So police can use either the Draeger Drug Test 5000 or a standardized field sobriety test to test for impairment roadside. On the basis of the results of either of those, they can arrest the driver and then put them through the drug recognition evaluation. The results of the saliva test on their own aren't admissible in court as proof of impairment without that failed drug recognition evaluation and subsequent testing.
Now, one of the problems with field tests, however, is the length of time it actually takes. Will this take a little more manpower?
The field tests don't take that much more manpower because they only require one officer to administer them. Obviously, there are concerns with any process about how long it takes, but the Draeger Drug Test 5000 doesn't cut down the process as far as time. Its sample collection period is a minimum of 1 minute and a maximum of 4 minutes of swabbing the device inside your mouth. The swab is then placed into the instrument, which does the analysis, which can take up to 10 minutes to complete. So we're talking maybe 15 minutes for the whole process. That doesn't really shorten things from conducting a physical test roadside.
Okay, let's talk a bit about the police officer's testimony in court. Is it more difficult for the prosecution to win with a field test, or is it tougher with a clear number from a testing device?
That's a really difficult question to answer because we haven't seen these roadside testing devices challenged in court as of yet. We haven't had cases go to trial where officers are going to be cross-examined on them. But in my experience, the physical coordination tests, because it relies on the subjective opinion of the officer at the end of the day, there's more fertile ground for cross-examination and more ways you can try and undermine the officer not administering it correctly. Judges tend to place a lot of reliance on science, so it might make the evidence stronger in court. But at the end of the day, at this stage, all a judge is assessing is whether or not the officer had grounds for a further arrest, not whether somebody was impaired.
Let's change gears for just a moment here. A 76-year-old Victoria woman has launched a constitutional challenge against the law that allows police to demand a breathalyzer without any signs that the driver's impaired. Can you briefly share what happened to this lady in a liquor store parking lot?
So this woman, who was completely sober, was stopped by police randomly in a liquor store's parking lot to check her sobriety. She was asked to provide a breath sample, and she attempted numerous times, but was unable to do so. She had a hearing before British Columbia's Superintendent of Motor Vehicles, similar to the Alberta Transportation Safety Board. And at the hearing, she provided evidence from her doctor confirming that she suffers from a medical condition, COPD, that affected her ability to breathe. The adjudicator at her hearing rejected that evidence and found that she had intentionally refused to comply with the officer's demand. She had her license suspended for 90 days, her car impounded for 30. She was referred to a remedial alcohol counseling program, which she had to pay for and complete before she was permitted to drive again.
Wow, so license suspension, vehicle impounded because she had a medical condition?
Yes, essentially, she wasn't able, in British Columbia, the burden of proof is on the driver to establish that they're innocent. And her evidence wasn't sufficient in the adjudicator's mind to prove her innocence. And even though the officer had no basis to think that she'd been drinking, because the law now authorizes random breath testing and random traffic stops for the purpose of random breath testing, she had a legal obligation to comply with his demand, even though she'd done nothing wrong.
So, Kyla, in your opinion, what needs to change with the law as you see it?
Well, I think the random breath testing provisions of the criminal code need to go. They are unconstitutional. The Supreme Court of Canada has repeatedly ruled since the early 80s that roadside breath testing violates the Charter of Rights and Freedoms, and it's only saved by the fact that people are asked to do this on the basis of an officer believing there's alcohol in their body. Now that Parliament has eliminated that, they've really put this legislation in a precarious position vis-a-vis its constitutionality. And I think it needs to go. I expect that the courts, particularly with facts like that woman's, are going to not be very sympathetic to the way that this law is being applied. It really seems heavy-handed in cases like that, where you have elderly people with documented medical conditions who are punished for doing nothing wrong.
So do you think the law will be overturned at some point in time? And if so, how long will that actually take to happen?
I believe the law will be overturned. Ultimately, this process is going to take several years. It's going to be a hearing in British Columbia's Superior Court. There's also a hearing, I know, coming up for one I'm working on in Yukon. There are challenges filed in Ontario as well. We're going to run the possibility with multiple challenges in multiple jurisdictions of inconsistent judgments between our courts. That has to work its way to the appellate levels of all of those courts. And then ultimately, this will be something that will have to be considered by the Supreme Court of Canada. It's probably going to be 3 to 5 years before all is said and done.
So let me ask you something. The police officers you've spoken to, Kyla, do they think it's more of a hassle, or do they think they're actually saving lives?
The majority of police officers that I talk to about this aren't huge fans of the new law. They find that it gives the police too much power. It's not that difficult for police officers to form a suspicion that somebody's been drinking. All you have to do is smell the liquor or have somebody admit drinking, which in my experience, most people tend to do. And so the police don't feel like this is something they needed. This is something that was the brainchild of our government and not something that police forces were saying is necessary to save lives.
I have to tell you about this time when I was playing a late night basketball game, 12 midnight, it wrapped up, I'm going through a check stop. The police officer with his 3-foot-long flashlight shines it in the window, says, "Sir, have you had anything to drink tonight?" I said, "No, not at all. I was just playing basketball with the boys." He says, "That's great. Go home, have a few beer and carb up." He's telling me to have beer at a check stop. Well, no, go home and have it, but obviously.
Yeah.
So it's good to see that our authorities have a good sense of humor as well. Kyla Lee is a criminal defense lawyer practicing at Acumen Law Corporation in Vancouver. Thanks a lot for joining me today.
Thank you for having me.